Thank you for your both. Okay. Yeah. First of all, thank you to both for your, time and coming to, help on this, the free seminar organized by the Diocese of San Antonio. So, uh, yeah, let's go ahead and get started, Mark, and then, Ponparthi, please coordinate with that, all the Q&A, and then, we'll take it from here now. Thanks, everyone.
Sure, Raju.
Yeah, so
Mark, back to you.
yeah, I'll go ahead. So thanks everybody for joining tonight. We're going to talk tonight about the very important topic of estate planning. We're going to talk about what estate planning is, why you need it, all of the documents that are included in a full comprehensive plan. We're going to talk about each of those documents and why they're so important to you. And then at the end, we're going to talk about, well, what are the ramifications if I don't do this? If I don't do it and something happens and I pass away without having these documents, what are the ramifications to my family? So we'll talk about all of that in about a 15-20-minute presentation, and then we'll answer any questions that you have. So as the presentation is going on, feel free to put your questions in the chat bar, and then we can answer those at the end. Yeah, I think this screen pretty much says it all when we talk about why is estate planning so important. And that word is family, right? We do our estate planning not for ourselves, but we do it for the protection of our family. I think one of the main things of why we do that is, if anything happens to us, of course, we want to make sure that our spouse and our kids, maybe our grandkids, are all taken care of. We don't want them to have to go through probate court. We don't want them to have to lose any money. And that's exactly why you create your estate planning documents. And that's what we do every day at NetLaw. We help families create their estate planning documents through a software that you can use that makes the process very, very simple and very, very affordable. So probably the first question that you have is, well, what is NetLaw? So NetLaw is a software company. We're an IT company that was created out of an estate planning law firm called the Hargrove Firm in Louisville, Kentucky. That's where I'm at. That's where our corporate office is. And the reason that our law firm created this software company was because way back in 2012, we read in a Bloomberg report that said that 60% of Americans didn't have their will. That's an alarming number. Today, that number is 67%. And, of course, being in estate planning, those numbers worry us, right? Because if you ask anyone, hey, do you have your will? Most people will say no. But, they always follow up with, no, I need to do that, right? So it's one of those things that we know we need to do, but yet we procrastinate. And there's a couple reasons why we procrastinate. One is cost, of course. It's very expensive to come into our attorney's office and get your estate planning documents done by using an attorney. But the second reason that people said that they procrastinated, they didn't think they had enough money or assets to even worry about it. I'm not a multimillionaire. I don't have multiple properties. I don't own a business, so I don't need estate planning. And nothing can be farther from the truth. If you own any asset, a house, a car, a bank account, you need your estate planning in place so the government doesn't interfere. And we're going to talk about that in a little bit. If you don't have these documents, the state comes in and decides things for you. And I guarantee those are some of the things you don't want them deciding on. So how did we create our software? From our law firm in Kentucky, we went out and we hired attorneys in all 50 states to come in and help us build our software. We wanted to make sure that no matter where you live at now or wherever you move to in the future, you have the ability to create your state-specific legal documents where those documents are prepared by an attorney. The software is created by attorneys, and you just use this software to go in and answer the questions that are asked, and the software builds your documents according to your state specifications. Very, very important. And one of two things that are very important with NetLaw is that we won the James Keene Award from the American Bar Association. That was an award that was handed out to the Hargrove Firm for their creation of net law. This award is given out each year to the company that has the best online delivery of legal documents. I'll say that again. The best online delivery of legal documents. That was awarded to the Hargrove firm for their creation of net law. We are still the only company in estate planning to ever win this award. And I only bring that up because I always get the question, well, shouldn't I go see an attorney? And I will always say, sure, if you want to go see an attorney, no one's ever going to say that that's a bad idea. But I just mentioned the statistics of how many people don't do that. We created net law for you to have a more convenient and less costly way to create your estate planning documents. And these are all the documents that you get in our full premium probate avoidance package. And the great thing about this package is one package, one plan covers both spouses. Both spouses get to create all of the documents that you see here on your screen. And let's run through these documents and talk about why they are so needed. And I always start with the will, because to me, the will is the most important document. And here's why. Think of your will as your listing document. We're going to list everything that's important to us in our will. Three of the major things that we're going to list in our will. One, executors. We have to name executors. This is the person or people that you will name who will take care of everything once you pass away. These people are responsible for the distribution of your assets to your beneficiaries. They're going to file your taxes at the end of the year. They're going to make sure that all of your creditors are paid. They're going to file your will with the county when you pass away. There's a lot of work that your executor has to do. Great thing about your executor is they have to be over the age of 18. But I always get the question, can my executor be someone from overseas? Absolutely. Absolutely. But in this system, not only do you name your main executor, but you name your successors or your backups to that main person. If that person can't do it, or maybe they need help, your successors can come in and fill in for them. And that's important because I always say, yes, your main people can be from overseas, but at least one person needs to be from your state. And here's why. There is a lot of legwork that has to happen. This executor is the one that's going to have to go to your house to find all of your documentations. They may have to go to your bank to find, your accounts and take care of that. They may have to go to your work for any kind of life insurance policies that you have here. So it's got to be someone local to make sure that everything gets accomplished. That's the great thing about having the main executor and your successors. So number one of three, your executors. Number two, guardians. If you are a parent of an underage child or children, and something happens to mom and dad, both of them pass away before the children turn age 18. Who do you want to have custody of your kids? Who do you want to raise your kids? We need to list these people in our will. We need to have them listed to make sure that if something happens, car wreck, plane crash, we saw it with COVID in our law office where both spouses passed away. Having these people named is very, very crucial. Again, you name your main guardians, and then you can name your successors, or I call them your backups. And the last reason that we create our will is we call it specific bequest. We're going to list all of our major assets and who those beneficiaries are. Here's everything that I own, and here's who's going to get it. Because the one thing we don't want is mom and dad to pass away and the kids start fighting over everything. Everything's going to be listed out, and those beneficiaries are going to be attached to each of those assets. That's your will. Executors, guardians, and listing those assets out. Second line item is included in the will and the trust. This is your children's trust. This goes back to those parents that have children under the age of 18. If something does happen to mom and dad and they both pass away before the children are 18, when do you want your child to receive their inheritance? And most people will say, well, let's get it to them at age 18, right? They're legal adults now. Let's make sure that the kids get everything because mom and dad are gone. But let's remember they're 18. Now, I always give the explanation, not speaking of your kids, but if my parents would have passed away and left me that money at age 18, you know what I would have been at 21? Broke, right? Right? Because all this money drops into an 18-year-old's lap. They're not thinking about saving for the future. But with the children's trust, the parents can dictate when and how much of that inheritance that you leave behind. And you can leave it to them in installments. So maybe some at 21, maybe some at 25, and the rest at 30. So as they go through life, increments are coming in. You can string it out all the way to age 35 if you want. That's the children's trust. Durable financial power of attorney. I think we all know what that is, right? Our POA. Naming someone who can make our financial decisions for us if we're incapacitated, whether we're sick, we're in the hospital. It could be that maybe you went overseas on vacation for 2, 3, 4 weeks and something happens over here. You don't have to rush back. Let your power of attorney handle everything with your discretion. I said in the beginning that this was a full comprehensive plan as well. Not only are we taking care of your financial documents, but we're going to take care of your healthcare documents as well. Your healthcare surrogate is your medical POA. If you're in the hospital, you can't speak for yourself. Who's going to speak for you when it comes to medical decisions? Who's talking to the doctors and nurses on your behalf? And your HIPAA authorization grants access to all of your medical charts to your healthcare surrogate or anyone else of your choosing so that they can have that informed decision. And your advanced directives are your end-of-life decisions. What do you want to happen at end of life? Do you want to be hooked up to a machine and kept alive? Or do you just want to pass naturally? The decision is yours and it should be no one else's. That's why we do all of these documents, to make sure that you are listing everything that you want to happen and when it happens. We even have a pet trust. So if you're a pet lover, great. You can leave money behind for the well-being of that animal. Someone has to take ownership of that animal if you pass away. You can leave money behind for them so that they can use it for the well-being of the animal. And then the last document is your revocable living trust. You know, when we talk about estate planning, most people say will and trust. Do you have your will and trust? Well, let's remember that your will and your trust, two separate documents that do two totally different things. Do they work hand in hand together? Absolutely, they do. Absolutely. But your trust is a separate document from your will. Remember, when I talked about the will, I said it was your listing document, where we're going to list everything that we want to happen. Think of your trust as your holding document. This is a document that you get to create where you can transfer ownership of your major assets that do not have named beneficiaries attached to them, like your home, cars, rental properties, businesses, vacation homes. Major assets that do not have named beneficiaries attached to them. You can actually transfer these assets out of your individual name and into the ownership of the trust. Now, you're probably, well, why would I want to do that? Because anything that is owned by the trust when you pass away avoids probate automatically. Anything that has a named beneficiary, like life insurance, 401k, a bank account that has a named beneficiary or TOD attached to it, all of those transfer to your beneficiaries right away. But what we want to protect is those assets that do not have named beneficiaries. Again, home, vacation homes, rental properties, businesses, those major assets, we can transfer them out of your name and into the ownership of the trust. When you pass away, because the trust owns these assets, they avoid probate and they pass to your beneficiaries right away. Let's talk about what probate is for those that don't know. So probate is a bad word. Nobody wants to go through probate. So probate happens when you pass away and you don't have a trust created. Your assets are not into the trust. The state will come in and freeze all of those assets from a period of usually 6 months to a year. The reason that the state comes in and freezes those assets is they're going to give time for creditors to, one, realize that you passed away, and two, file a claim on your estate. Hey, you owe us something. We need to be paid off. And what the state says is, we're going to freeze these assets until all of the creditors are paid off. Once the creditors are paid off, then those assets transfer to your beneficiaries. Again, probate lasts usually 6 months to a year. That means those major assets that we talked about will be frozen for 6 months to a year. One of the big things that we want to happen when we pass away is to get those assets to our beneficiaries right away, so they can decide what they want to do with it. Do they want to keep the asset? Do they want to sell the asset? But you can't do anything if it's stuck in probate process. That's why having the will, listing everything so we know what's going to happen, and having the trust to make sure that the state doesn't get involved and those assets get directly distributed to our beneficiaries. That's all the documents in the full comprehensive plan. And we even have a 7-day money back guarantee. If you don't like it for any reason, we'll give you your money back as long as you haven't downloaded your documents. Again, all of this, one plan, covers both spouses. And remember when I was talking about the James Keene Award, I said there were two things that separated net law from everyone else in this industry. One was the James Keene Award. Best online delivery of legal documents from the American Bar Association. Here's the second one. Not only do you get to create all of these documents for both spouses, but anytime there's a life event that happens to you, you can log back in, because this is a software, you can log back into your account and edit your documents. Here's the kicker. Free of charge. We have no subscription fees. Most companies charge about $10 to $30 a month to keep your account open and active. We don't charge anything. You pay the one-time fee to get started, and that's it. Just make sure that when you create your documents, or you go back and you edit any document, that you have to print that document out and get it witnessed and notarized. Full protection for your legacy. That's why we do estate planning. So why is estate planning so important? I think we talked about it, right? We talked about the need for a company like NetLaw to allow you to not have to go see an attorney, but use a software that has been created by attorneys, so you still have the state-specific documents that you need. Full legal documents. But the last 4 slides I'm going to show you, probably the most educational, or at least the most informative, I think. Because now we're going to talk about the ramifications. Hey, this webinar ends, we all go on with our lives, right? If we don't do these documents and something happens to it, what are the ramifications to our family? Most people just assume, well, if I pass away, my spouse gets everything. That is not true, not here in the US. So if you pass away and you are the sole owner of an asset and you do not have a will, the state will decide how that asset gets distributed. It's called intestate. That's the only legal term that I'll use tonight. Intestate simply means that you passed away without a will. And the state comes in and says, okay, you didn't tell us how you wanted your assets distributed. We're going to do it for you. No one wants any kind of government interference in their life, especially when it comes to how our assets are going to be distributed. So if you're the sole owner of an asset, or you're the second spouse that's alive, even if you have let's say your house, you own it and your spouse owns it, right? Both of you are on the deed. The first spouse passes away. There's really no ramifications to the second spouse. They own the house. But when the second spouse passes away, everything goes through probate. It won't be distributed to your kids. It's left up to the state to decide. Having that will, remember, we list all of our assets and we name those beneficiaries. I can't tell you how important that is. Even more important than this, if you don't have a will and both parents pass away before the kids turn 18, a judge will dictate who gets custody of your kids. A judge. Now there's 40, let me put on my reader so I can read it. 43 of us on this call. I guarantee all 43 of us don't agree on everything. But I bet we all agree that having a judge make that decision is probably a bad idea. We know who we want to raise our kids if something happens. God forbid, right? God forbid something happens. But if it does, you already have who you want to raise your kids in place. Again, government interference. Judge comes in and decides who gets custody of our kids. No one thinks that's a good idea. And I'll tell you what's even worse. The person that the judge names has control of your inheritance that you leave behind for your kids. I think we better make sure that we know who that person is. Again, with the will, we list our guardians. And we definitely want to avoid probate court. Probate court is terrible. It's very expensive. If you fight the probate process, you have to go to court. You have to hire an attorney. They go to court for you, or you can go with them. On average, to fight it is probably usually about $6,000 to $8,000. That's money that should be going to the kids, but yet it's going to the attorneys and the court system. And you still have to pay off the creditors. Simply creating that trust and transferring those assets that we talked about. And we have a funding instruction sheet that walks you through how to do it. I know, listening to me, because I would be thinking the same thing. That sounds very complicated. How do I transfer my stuff? Believe me, it is easy. It is as simple as doing a deed transfer of your property at the county clerk's office. I did mine about 3-4 years ago. It literally took me 15 minutes, and I think it cost me $79. I took my deed that I had to my house, went down to the county clerk's office. They created me a new deed in the name of my trust. So the name of my trust is the owner of my house. Now, I'm still the trustee of my account for as long as I'm allowed. I lose no power, no authority. I have full control over everything. But yet, if something happens to me, I know my kids don't have to worry about probate court for my large items. Not only does it make me feel good, just think how relieved they are. Last screen. Don't skip out on those medical documents. The one thing that we don't want is you're at end of life and your family's huddled up in a corner somewhere and they're all discussing, should we take him off life support? Should we keep him on it? We've never had this conversation with our family. We do all of these documents to let them know what our decisions are. Again, I said it earlier. We do all of these documents to keep you in control of everything. No one else. not even our family members. We know what we want to happen. Having these documents ensures that it does happen. So we're keeping the power and the authority with us, not the court systems, not the attorneys, not the doctors. We're in full control of everything. That's what we do every day at Net Law. We help families create their estate plan online in the convenience of their home. The process takes under an hour. And you get the same exact documents you would get as if you went to an attorney's office. I'll stop here. And let me turn it back over to you, sir. And if there's any questions, let's get those answered.
We have a couple of questions, Mark, so I will go over, and whoever has any questions, please put it in the chat. Okay, the first one is, will the slide deck be available after presentation?
Yeah, I can get you, I can send you this presentation, and if you want to share it, you can, sure.
Okay, yeah, I will share with them. And can I name a friend as an executor, or does it need to be a blood relative?
No, absolutely. It can be anybody you want that's over the age of 18. So it could be a family member, it could be a friend, it could be anyone.
Okay, the next one is, how much you charge for will and trust?
Yeah, so our price on this is $600. And again, that covers the documents for both spouses and unlimited edits to any of the accounts.
Okay, and the next one is, you mentioned that the documents created by the software are state specific. Will the judge in Texas accept the documents?
Absolutely. We've never had a document that has failed in court. Never. Never. So yeah, if you're in Texas, you have Texas state specific documents. Absolutely. You can be 100% sure that you can use these documents in court.
Okay, can you please talk about transferring your shares in an S corporation to your trust?
Yeah.
With reference to IRS, State Secretary of State and Loans.
Yeah, so we'll answer it a little bit, but I will tell you, if you are transferring your shares of an S corp into your trust, you are going to want to talk to an attorney, because it is very complicated to transfer a S corp into your trust. And what you'll do is you'll just transfer those shares out of your name into the name of the trust. But there is a lot that has to go involved. LLCs are pretty easy. S corps, I'm going to highly emphasize that you need to talk to an attorney. And if you need one, I can refer one from your state to you, and they can help you with the transfer of your shares of the S corp into the trust.
Okay, how does the law firm get to know about overseas death?
Well, we wouldn't. So, that's why you have these documents. Once you pass away, your executor takes over from there. So, we're responsible for creating these documents for you. After that, everything is in the hands of your trustees and your executors to make sure that everything is distributed. If they need help, they can always reach out to us, and we'll try to help them in any way we can. But again, just like any attorney's office, we're there to create the documents. Once you're done, it's up to your executors to take care of everything.
Okay. Does a person living outside the US need to come here to execute the trust, even though we have a friend listed as trustee?
Yeah. So the executor, if you're I think we're talking about the executors, correct? Is that right?
Yes, executors. Yeah, executors live in, yes,
Yeah,
executors live
they would
outside
have to
US.
come. Yeah, there's a lot that's going to have to happen. So that's why it's so important to have those backups named, especially someone from your state. So your executor overseas can handle everything that they can abroad, but you have your one person that's named here from your state to do everything local. And they can work together on that.
Okay, will everything be executed online, signing documents and access to the documents?
So you create your documents online. You have an account that you would log in with your email and a password. You create your documents, you print them out, you take them and you go get them witnessed and notarized. And you can even scan them back into your NetLaw account. So you have your hard copy and you have a digital copy as well. Anytime that you need to come back and edit your documents, you just log back into your account and you go make your updates and just print out those documents again and get them witnessed and notarized.
Okay, what happens if the law firm dissolves or goes bankrupt? Will clients be notified?
Well, they would. If NetLaw somehow goes out of business, we would let all of our clients know. The thing is that you would still have your hard copies, so you still have your full legal documents on hand.
Okay, do you suggest any plan for term insurance?
Well, that's a question for you. That's a question for you.
I will take it. Yes. Yes. So yeah. So whoever wants to do a term insurance, I can help you. So you can text me or we can talk after this. Okay. The next one is, what does $600 for the software cover?
Yeah.
I think
So let me go back to this, and it covers all of these documents right here. So everything here is covered. For both spouses too.
Okay, so I'll go to the next one. Do we need to open a locker to keep the document safe?
You don't have to. I mean, again, you can upload these documents to your to your NetLaw software, so you have your digital copy. But for your hard copy, I think it's a good idea. You could have a locker at the bank, or you could keep them in a safe at home. So anywhere that's safe, that's where you want to store them.
All right, and the next one is, does $600 include notary, lawyer signatures, first-time documents created, and what happens after each edit? It will need a lawyer sign.
Yeah, lawyers don't sign this. So you print out your documents, you get them witnessed and notarized. They're full legal documents. You are using this software to fill in the blanks of the software. So you're filling in the documents. So yeah, you're going to create all of your documents. You're going to print them out. You're going to get them witnessed and notarized. If you need someone to review them, there's a chat bar in your NetLaw agent account. You can click that, talk to one of our representatives. We can turn that chat into a video call. And that video call, we can see your screen. And we can just make sure that all of your documents are created correctly.
Okay, so what steps should be taken after creating a will and trust using estate planning software?
Yeah. So
That's
you print them out, you get them witnessed and notarized, you scan them back into your account. So you have a hard copy and a digital copy. And then you want to go ahead and fund those assets into the ownership of the trust. Then you're done.
Yep. So will the executor or trustees get a copy of will and trust?
Well, they should. Yeah. That, if you want to give them a copy, absolutely. I gave mine a copy. So if anything happens to me, they're ready to go.
Right. Can anyone guide to do it online?
Absolutely. Yeah. I even have a demo video that you can receive that walks you through how to complete all of these documents.
Yep. Can anyone, after I fill up and assemble the documents, what's next?
What's
Can
next?
we create a revocable trust, get it notarized, and share a copy of the documents with the executor? Yes, so this is
That's
also
correct. That's correct. Yeah.
The next one is, how does your firm protect the privacy of the client as the documents are created online? What kind of security breaches you had in the past?
Yeah, we've had no breaches in the past. So we use Microsoft Azure for our software. We've completed our SOC 2 audit, and we just completed our SOC 2 level 2 audit. So again, privacy is a big concern of ours. The great thing is you're not putting really any personal information into the software. If you're adding like your, let's say your bank account, don't put in the full account number, just put in the last 4 digits. We don't ask for your social security number anywhere until you print out the documents, and then you have to actually handwrite it into your certificate of trust. So that never appears in our software anywhere. So we take privacy, your privacy, very, very seriously.
Okay, so I'll be interested in term life insurance policy. Please send me an email. Okay, I'll take care of that. And the next one is creating will and trust. One and done thing. Why do other organizations have subscription fee, assuming there are no life event changes?
Well, they want your money. It's as simple as that. It's a great revenue generator.
Okay, I have notarized and witnessed will and made digital copies of it and gave it to the guardians. Is this similar to will I already have?
Yeah, this should be exactly the same, except with the changes that you've made. Your will created with us is a fully legal document in your state.
Okay, are digital copies of estate planning documents considered legally valid?
Absolutely. As long as you have a witnessed and notarized digital copy, absolutely.
If any questions come up and we use chat or video services, is there a charge?
No, there's no charge.
Anything I need to file with the county?
Your will, you can file your will after everything's done with the county, or your executor can do it upon your death. So it's up to you. If you want to do it, that's fine. If you want your executors to do it, that's okay too.
Okay, so maybe you missed my question. So sending here again. Is it must have a trust if a will already exists? Sorry about that. Yeah. Is it must have a trust if a will already exists?
Well, the easy answer is no. You don't have to have a trust. If you want everything to go to probate and your beneficiaries wait 6 months to a year to get your assets, then you don't need a trust. If you want them to receive everything right away, then a trust would be needed. That's kind of how I put it. That's the easiest explanation. Remember, that's the whole reason we have the trust, is to make sure that your beneficiaries receive everything right away.
It looks like there is not lawyer in the whole process. Is that correct?
Well, the lawyers have created the documents. The whole software has been created by attorneys. Here's really the process. If you go to an attorney's office, you go into the attorney's office, the attorney comes in and asks you a bunch of questions. And as you're answering those questions, the attorney's writing down all the answers. Then they go back and they create all of your documents. This is the same process with our software, except you're entering the question or the answers into the software. Then it builds the documents, same as the attorney. So yes, there is an attorney there. They've created, that's how you're getting the state specific documents, because the documents, the software has been created by attorneys.
Every time I make changes to the will, do I need to get it witnessed and notarized?
Yes.
Would the hard copy of will and trust still be valid forever, even after the law firm dissolves or anything changes on law firm?
No, absolutely. They're full legal documents, no matter what happens to us.
Is trust text?
No, unless you have assets over 26 million as a U.S. citizen or green card holder for a family, then the inheritance tax would kick in.
Every time I make changes to the will online, do I need to get witness and trust? I think we answered this. Yes.
Yes.
The next one, how big is your company Netla? What is your annual revenue? Are you listed in NASDAQ and New York Exchange?
No, we're not a public company. We're a private company. Yeah, I don't know what you mean by how big. We're a software company, so it's nice size. Of course, I'm not going to tell you our annual revenue.
You guys have any other question? I think we covered. If I missed anything, please let me know. Okay, someone joined now. Let's see whether they have any questions.
And I wanted to ask you one thing, like, since this webinar organized by India Association of San Antonio, if anyone a member of our India Association of San Antonio, if they come and take your service, will there be any discount, Pon Bharati or Mark?
Yeah, yeah, we'll take it up. Yeah, so we'll see how we can do it, Raja.
Okay.
So I'll work with Mark, then we will come up with the discount.
Okay, sure, sounds good. So who are in the call, if you're planning to reach out them, please, let reach out to any one of our India Association of San Antonio executive committee member. We will help you to get some, discounted price through us. Okay.
I think we got a couple more questions, so I'll just go over again. Is it acceptable to have multiple notarized copies of a will and trust?
Absolutely. Yeah, there's nothing wrong with that.
Okay, and the next one, how do we contact you? Yeah, you can contact Raja, and Raja knows how to contact us. Okay, I think, yeah. I think that's all we have.
These are great questions. Really good questions.
Okay, thanks a lot, Mark. Do you guys have any other questions?
I just had a question. So, Mark, what is the role you play? Are you a sales consultant, or what is it?
Well, I'm the vice president of the company for sales and service.
Oh, I see. Okay.
Okay. Okay, thank you guys. So if you don't have any other question, then we'll wind up. Yeah, that's okay. Okay, no more questions, I guess. Mark, thanks a lot, Mark.
Yeah, thanks. I really appreciate your time, Mark. Really, on behalf of India Association of San Antonio, I would like to really appreciate your time and explaining that very important topics for our, to
Absolutely.
everyone. And also thanks, Pon Bharati. When I reached out for help, you always, help me. Thanks for all the support. Yes, thanks everyone who joined the call. As I said, if you're planning to reach out them, feel free to contact any one of our IASA executive committee. We'll help you to connect. Yeah.
So Pon Bharati, you are based in San Antonio, correct?
No, I'm based on New Jersey.
New Jersey. Okay. And Mark, you're in Kentucky, right?
I am. Yes.
So Rajguru, you're in San Antonio, right? So
Yeah, we are from India, San Antonio.
Yeah.
From
Can
San
you
Antonio.
put your, if you don't mind, can you put your email address so that we know who to contact, if you don't mind?
Yeah, sure. I'll put it on chat right now.
Yeah, if you don't mind. Okay. Thank you.
I'm putting right now so that before leaving everyone, just make sure, and make a note of this.
One more request. Since this meeting is being recorded, is there any possibility that the recorded version can be sent to all the registered people for this one?
Mark, is it okay to share?
Yeah, it's not with me. Yeah, absolutely.
Okay, yeah, sure. I will share with Raja.
Yeah, thank you.
Okay,
Yeah,
thank you.
my information, I just shared it on the Zoom chat. Please, please make a note of that. Email me or text me. We'll help you to guide, okay?
Okay, so yeah, thanks everyone, and talk to you soon. Thank you.
Yeah.
And thank you,
Thanks,
Mark and Raja.
thanks everyone. Have a good night. Bye.